other hand, claimed that the regulation violated equal protection of the law under the federal Constitution because they said it was racially discriminatory. It was designed to discriminate against them. So they had a claim under the circumstances for a denial of equal protection. So the case came into the federal courts, and the question was whether the federal courts should hear it or not. There was jurisdiction to hear it. The case did involve a matter of federal law, namely the equal protection claim. And under so-called pendant jurisdiction, federal courts can hear federal issues and all the related state issues. So they could have heard the case. But the case went all the way up to the Supreme Court, and the Supreme Court said that in addition to the general rule that federal courts ought to avoid, when possible, deciding constitutional issues unless they have to, the court said when you have a case like this that involves a matter of constitutional law, but also involves unresolved questions of state law, federal courts should abstain from hearing these cases and send them to state courts. Get the state courts to resolve the state law issue first. Now, why would the Supreme Court say that? Well, it may avoid the constitutional question. It may avoid it because depending upon how the state law issue is decided, it might just turn out that there's never a need to decide the constitutional question. For example, in the Pullman case, if the state court said yes, the Texas Railroad Regulatory Commission was acting ultra vires of state authority, and therefore its regulation was impermissible, there would be no need to decide whether the regulation also violated equal protection of the law. So it makes sense. In addition, there's another rationale for this kind of abstention, and it is comity. That's C-O-M-I-T-Y, or respect for the states. The idea is in essence, is that if there are unresolved issues of state law in a case, let the states have the first crack at deciding what their own law means, instead of having federal courts speculate about what their law means and then also reach the federal question. Let the state courts go ahead and decide what their own state law means. Now, the classic instance for applying abstention, Pullman abstention then, is where you have a party trying to go into federal court, and there are unresolved issues of state law involved in the case, and the federal courts will abstain because they want the state courts to resolve the questions of state law first, and maybe the federal courts will never have to decide the federal constitutional question. And in any event, it accords respect to the states to let them, in the first instance, say what their law actually means. Now, given the rationale for the doctrine of abstention, Pullman abstention, there are occasions where this form of abstention should not apply. Certainly it should not apply and will not apply if there's a state law issue in the case and the state law on the point is clear. Or, no matter what the state law issue is, the federal constitutional issue will always remain. Now, because abstention is a discretionary doctrine, federal courts need not apply it in circumstances where you have some special facts. Let's say you're told that it will involve undue hardship or some very serious kind of delay to the parties if the court invokes the abstention doctrine. Then the federal courts can relax it. But otherwise, abstention should be applied in that kind of a case. Now, there's a second kind of abstention as well, and that is abstention where the matter brought before the federal court is already pending before a state judicial or administrative tribunal. This form of abstention arises from a case called Younger versus Harris, and it's sometimes referred to as Younger abstention. And it's applied very, very vigorously, most vigorously, in circumstances involving criminal cases. And to set the stage, let's say the state government is about to prosecute you or has commenced a prosecution against you in a state court on a criminal case or a criminal charge. You had circumstances where defendants, being faced with a criminal prosecution in state court, were running across the street to a federal court and filing an action for a declaratory judgment that the state law under which they were being prosecuted was unconstitutional, or they were seeking an injunction against the prosecution. And the court in Younger versus Harris essentially said, where a state proceeding is pending or has already begun, and most particularly in criminal cases. Federal courts must abstain and allow the state courts to continue deciding the case. Now, this kind of abstention is far more disadvantageous to defendants than Pullman-type abstention, where the court retains jurisdiction and just wants to get the state law issue decided. In this Younger abstention, what the court is basically saying is, no, the case has already started against you in state court. You go back to state court and raise your federal constitutional claim as a defense or as a collateral matter there. And the court will allow the state courts all the way up through their processes to decide the matter. And should a federal constitutional claim remain at the end of the day, when all is said and done through the state court system, then plaintiff or defendant, you can attempt to get us to review it by way of our appellate authority. In addition to applying in criminal cases, Younger abstention also applies in other proceedings in state courts. It applies, for example, when there are civil or administrative proceedings pending in state courts or tribunals. Federal courts will refuse jurisdiction if these cases are pending. For example, cases involving divorce or alimony, child custody, administration of estates, administration and enforcement of state court judgments. The court has even said in a case involving two oil companies, the case was Pennzoil versus Texaco, that this form of abstention should apply where state proceedings are underway involving private litigants. And this really nicely illustrates Younger abstention, this Pennzoil case, and is quite an interesting case. In that case, the plaintiff, Pennzoil, got a $10.5 billion judgment in the Texas state courts against Texaco Oil Company. And Texas procedural rules required that when you had a judgment against you, in order to be able to appeal, you had to post a bond for the amount of the judgment. Now, even for Texaco Oil Company, posting a bond for $10.5 billion was pretty difficult, pretty steep. So what Texaco did is it ran straight over to the federal court and sought a declaratory judgment that this procedural rule was unconstitutional, that it violated due process of law, and it sought an injunction against its enforcement. And the lower federal courts entertained that suit. But when it got all the way up to the Supreme Court, the Supreme Court said, no. The state courts already were vested of jurisdiction of the matter. There was no reason to believe that the parties couldn't litigate the constitutional issue, this due process attack on the procedural rule within the state courts themselves. There was no showing that the state courts wouldn't be open to these claims or that they wouldn't treat them fairly. No, it had already begun in the state system. Let the state system have it. Raise your claims there. If they remain when all is said and done, and you've gone entirely through the state court system, then attempt to get us to review it as part of our appellate review. But until then, we're going to abstain and not intervene in any way by granting an injunction or declaratory relief. So when you're thinking about when federal courts can act, there are a number of things you have to keep in mind by way of review. You have to think about Article 3 and whether the particular case comes within the Article 3 jurisdiction. Whether even if it does come within that jurisdiction, whether Congress has conferred that jurisdiction under its jurisdictional statutes. You have to think about whether the 11th Amendment is a bar, and whether, beyond that, even if you do have jurisdiction in a federal court and 11th Amendment is not a bar, the doctrine of abstention will keep you out. So be alert. If you're dealing with a question where the facts say that the parties are suing in federal court, or if the question asks you to discuss all issues if a party proceeds in federal court, then you have to consider whether you're allowed to be in federal court. And these are the kind of limitations that you have to keep in mind. Now, sometimes the issue about jurisdiction will be obvious. For example, you may be given a straightforward question where you're told that Congress has passed a statute curtailing the jurisdiction of the federal courts or the Supreme Court. But in other cases, it might not be so clear. So keep this sort of mental checklist in the back of your mind when the facts say that you are in or are attempting to go into federal court. Is there jurisdiction? Now, as I said before, there are two main limitations on when federal courts can act. One is jurisdictional, but the other is this matter of justiciability. A federal court won't hear a matter where the particular case in front of it is not an Article III case or controversy. And by that we mean, remember,